Okay, I guess we can get started. Let me call the Town of Washington ZBA meeting for February, a regular February meeting to order. On tonight's agenda, there are 4 items. There's the Hurley one for replacing the existing screen porch enlargement on 199 Mildwood Road. A milk coat, an area variance for front yard setback, the 25% rule, 55 Dayham Road. The Mulvey area variance for a second floor addition to the garage on 247 North Mabbittsville Road. And the last item is yard guard public hearing for an appeal for the variance of the swimming pool at 610 Stanford Road. Before we get into the first one, we have minutes from the December 19th meeting.
I have no changes.
Changes, additions, corrections, then
I would make a motion that we accept the minutes.
I'll second it. Motion by Frank, seconded by the chair. All in favor?
Aye.
Opposed? Motion carried unanimously. Okay, who's representing Hurley? Come on up.
Hello. How you doing, Michael? Good. How are you?
Yeah.
And Happy New Year.
Happy New Year.
Happy Chinese New Year and all the others. I'm here, Michael Sloan from Sloan Architects, representing the Hurleys for their screen porch replacement.
Everybody on Zoom hear us?
They're all muted, so if they said
Okay.
yes.
Okay, go ahead. Sorry, Michael.
The scope of the project, like I said, is to replace a smaller screened-in porch off the back of their house with a larger screened-in porch. To take advantage of be able to gather outside and not have the bugs in their yard. So this project is, the reason we're in front of you is their house is a non-conforming structure on the property, because the property, even though it's a larger parcel, the house was built close to the property lines. As you'll see from the topos of the site, it drops off dramatically behind the house. So it kind of limits where the addition can go. The addition itself, being that it's a non-conforming house, it was built in 1987. I don't know the exact month because that's the year of when the law got passed of that 25% increase rule. So I'm not sure if it was before or after, to be honest with you. But saying that, we are still under the 25%. So it's approximately, just actually under 23%, the expansion of the screened-in porch. The main thing about this porch is it's on, being that the house is built into the hillside, the porch is actually at the first floor level, with the first floor, so the, kind of the entry level of the house. And the porch is actually built on piers, and 2 reasons. One, obviously, to have the porch at the same level as the main floor, but also allows the owner and people maintaining the property to be able to drive underneath of it with the tractor, because otherwise, the hill, the toe of the hill is so close to the porch. It allows them to maintain the property, and also has less impact in terms of soil disturbance and everything, because we're really just adding the piers underneath the porch. The terms of, other aspects of the zoning, the lot coverage is, being at the larger parcel, we're only at even with the addition, we're at 1.9% of coverage. The other aspect of this project is because of the terrain where we're building, even though we're close to the property in terms of where the structure is, the neighboring properties here and over here, the site drops off so dramatically that as you see a bigger, it shows up the best. The neighboring lot houses here and here, because of even though we're close to this inside corner, this is a very dramatic hill, we'll call it. It drops, there is a pond that is behind the house.
So the high ground is here?
The high ground is along the road.
Okay.
It actually is going up very steep here.
Mhm.
Even the road's actually steep going up. But after this, from this point on, you'll see in the topos, it drops about 50 feet in elevation drop to the pond. The pond's, the pond itself, you can see this document, see how close it is.
For everybody to see.
This is just off of parcel access, because Brian House and the surveyor didn't go all the way down to the pond. The distance to about the edge of water, it's about, I'll call it 175 to 180 feet away and 50 feet down. So it's a pretty, I'll take another discrete picture of it so you guys can see. So this is, you know, this is the level of the grade here, and you can see we drew a blue line in the it's about 50 feet in terms of the topo drop off to the pond. The yard, the reason I brought this picture into is to show you what it looks like in behind. The site is actually there is trees on the site, and pretty much this hill is very light topsoil with basically solid shale all the way down to the water. The shale is all the way, you can see it all the way down the hillside. That gives you kind of an idea of the parcel itself. In terms of what one sees, it's basically an outdoor living room with an outdoor eating area.
Is it a screen porch?
This is a screened-in porch.
All right, so it's 3-season.
It's 3 seasons.
Hmm.
There is no paneling, but it's 3 seasons in terms of
Use.
use.
Hmm.
So it is screened, and it's not going to be like glassed in or anything. And these are the piers I was talking about in terms of there's the access going underneath that allows the person to get underneath and through here. There is this wall, the house has stone retaining walls in the front of the house. So this wall over here, which is allowed for grading to get a lawnmower to get down, so that transition will be matching the existing stone walls of the house. So as you can see, it's a classical design.
R5, right? Zoned R5, correct?
Yes.
Okay. And, the variances that-
Correct.
Side yard is left outside.
Right, so the rear yard and the side yard.
Which side yard?
So the rear yard, the street is pit orientation. The road is here,
Mhm.
Wood Road. Driveway comes in. So that's the front yard. This is the rear yard. We're calling this the side yard, because it, basically cuts it off. But the yard goes like this, and this.
So it would be the north, because
side.
north goes that way, right?
This is north.
That's west. West is where you're sitting.
Yes, I'm west, correct. So we have the 75 feet. 75 feet for the rear yard. And so the distance perpendicular off of the addition is 24 feet,
3 inches,
and 3 inches.
or
from
3
founded off.
tenths rather.
Correct. And then we have 33 feet and 1.5 inches from the rear yard.
So then from the west side, okay, you're asking for the side yard for 50.7 inch variance, correct?
Correct.
And from the rear, you're looking for a variance of 41.9.
Correct.
Okay. And the pond you said was like 175 feet away, so you're well without a buffer area, correct?
Correct.
Okay. Any other questions, Frank?
I don't have anything now.
Al?
No questions.
Nothing.
Okay, I'll make a motion to open the public hearing.
Second.
Second. Motion by the chair, seconded by Frank. All in favor?
Aye.
Opposed? Motion carried unanimously. Anybody from the public interested in the Hurley application?
Okay. Motion to close the public hearing?
Second.
Motion by Frank, seconded by Tate. All in favor?
Aye.
Aye.
Opposed? Motion carried unanimously. Okay, this is a type 2 action, so
Yeah, I would make a motion that we classify this action as a type 2 under secret.
wait a second. I'll second it. Motion by Frank, seconded by the chair. All in favor?
Aye.
Aye.
Opposed? Motion carried unanimously.
All right, John. Who was the second on that?
Me.
Oh, you. Oh, yeah, thank you.
There's 2 variances requested, and I would preface this by saying that any approvals tonight are contingent on site plan approval being obtained from the planning board. I would make a motion that we grant a west side yard variance in the amount of 50.7 feet and a rear yard variance of 41.9 feet.
Motion by Frank, seconded by Tate. All in favor?
Aye.
Aye.
Opposed? Motion carried unanimously. Now we need a motion for the special permit contingent on the planning board approving the site plan.
Correct. I'll make that motion.
I'll second that. All in favor?
Aye.
Opposed? Motion carried unanimously. So it goes to the planning board for site approval.
And
Okay,
then you're,
if they approve it, it's okay. Otherwise, it has to come back to us.
okay.
Thanks, Michael.
Thank you.
Thank you.
Hi.
I'm looking at what it is. To, and roof over the top of their existing garage. create, just more businesses for their growing family. They have a special permit for the garage as it exists. This is what it looks like right now. It's just a flat roof. Right there.
And that's where they want to build over top of the
Yeah, they
garage.
just, you see that roof line right there? It's really a story and a half to that roof line. They're just gonna extend it to the end of the garage.
Okay.
And then there's living space in there, so it's more like a roof
Mhm.
than another story.
Mhm.
And so this already has a special permit, but I guess we need another one to do that little bit of work on.
Yeah, that and some variances.
There's no bathroom.
They would like a bathroom, it's not a deal breaker. They like to put just a small one up there. But it won't change the amount of bedrooms, it's still just 3
That was
bedrooms.
my question.
Yeah, no, it
Whether it's
stays-
changing bedrooms.
No, so their downstairs right now is actually like the dining room is their bedroom. Right now, so they would just put their bedroom upstairs and just have more living space downstairs.
Mhm.
And it's in conjunction with the neighborhood there. I know this is technically zoning, but the houses that are right in that little area are smaller. Makes no sense.
You said there's a special permit for this.
That's my understanding. Yeah, there's already a special permit for that from some years back when they went to build it. It was already granted to them.
Oh, so it's been granted, it's.
It's
all
granted, right, that's old,
It's
that's
old.
old news.
done. Old news. We don't need to know.
No, no,
Okay.
it's just, 24. No. 14 by 24. That's- Not changing anything in the environment there, there's no, not breaking any ground or. Changing it. I think it will look better.
Use the proposed expansion, I thought was above the 25% rule.
It's below
It's below at 24%, right?
for this.
So then the only variance you need is for the side yard setback.
Well, I think there was that, and I think that, yeah, I think that's correct.
Alicia, you familiar with this, Alicia?
Is the expansion 35%?
That's what we have, so I'm checking the map right now.
That's
25%.
It-
It's gonna be 24%, with the rounded.
It doesn't exceed 25%?
Let's go ahead and compare.
Yeah.
So it comes to 24.
Yeah, Aaron
Yep.
said that, sure.
The code compliance.
So it's, okay, then, he's saying it's 2 variances.
Yeah. Variance to increase the bulk within the front yard setback and one within the front setback for the rear addition and the west side.
Do you look at this as an addition, even though it's the roof? That you're kind of extending, that you're extending, or assuming? I mean, it's not infringing on any of, it's not changing the footprint at all.
That's a good question.
So what you're saying is there's no expansion of the footprint of
No,
the
no,
structure. It's just simply you're now turning a roof into an occupied space.
Right, well, you can when you dormer, so if you were to
Right.
go up there, you'd see that there's
Right.
bedroom. So this roof, this line right here is just gonna be the same roof line to the, just to the end of the garage. I don't know why they didn't do that to begin with, so it'll look even across.
Right.
And then that space is usable. It's really an attic, technically. But when you dormer it, you can,
But there's
Yeah,
nothing
it's-
going on
No,
extended on the ground of
Not
what's
at all.
already there.
there's no bucket going in that ground and digging it all. It's just what's on top of that garage.
I'm confused, and why are we talking about side and rear? I kind of agree with you, Al.
Yeah, I don't know.
What do you got?
If that's all it is.
This was actually a topic of discussion, so I think initially it was at 2, and then looking at it more in depth, we had the front porch needed a variance. West, hold on, let me. Right, so the front porch would be further encroaching into the front setback, so that would be one. The west side addition would also need a variance for the front yard, because the whole house is in the setbacks, like any expansion to it is also going to trigger a variance. So we had, at the front porch, the west side addition, then for the increased encroachment, and then also for that same addition, a variance to increase the bulk within the setback. For the rear addition, even though it's in the rear of the house.
No, we're talking about different.
Must be a different.
This is the
project.
Mulvey.
Did I just?
Yeah, this is Mulvey over on,
Never mind,
I
We
was
went
starting
on-
to get scared. I was
Delete
thinking
all of that.
We went out of order in
Yeah.
the agenda.
Yeah, my confusion is if they're not expanding the footprint of a non-conforming building as it is, do they need any variances? Seems to me that they may not,
That's where it'd be parked, because we
Just need
always
to-
looked,
just need a special permit for the expansion.
and then to the planning board.
Right,
Okay,
Yeah, that makes sense.
makes sense to everybody?
Yeah.
Yeah.
Kyle, that
Yeah.
makes sense to you?
No, I agree with what Frank just said.
Okay, so.
write that
Okay.
down that Kyle agreed with
There you
me.
go. Well, we have a stenographer to tell.
She's not recording.
Okay,
But she can for that, Kyle.
yeah, that's good.
I-
I'm not getting the bill.
so then we don't,
Frank is.
Yeah.
do we need to do anything. Kyle, do we need to do anything from a seeker point of view?
Well, it's still, you still have to do
Type
type
two.
2 action. You declare it a type 2, and that's fine, and then you refer it over to the planning board.
Yeah.
Okay,
I'll make a motion that we declare the application. of type two.
no, we do a public hearing first.
Oh, that's right, we should. Okay. I'll make a motion to
I have
open
a
the public
question.
hearing.
I don't have a map of CHC, any
Second.
wetlands near the.
Motion by Frank, seconded by Tate, all in favor?
Aye.
Opposed, motion carried unanimously. Kim. Anybody here interested in this application or have a question?
I asked already.
You got your answer? Okay, can I have a motion to close the public hearing?
So moved.
Motion by Frank, seconded by the chair. All in favor?
Aye.
Opposed, motion carried unanimously. Now do your seeker.
Yeah, I'll make a motion that we declare this application of type 2 under secret.
I second the motion.
Motion by Frank, seconded by Alex. All in favor?
Aye.
Opposed, motion carried unanimously. Now do your special permit.
Yeah, I would make a motion contingent on planning board approval of a site plan to grant special permit for increasing the size of the home by no more than 25%.
I'll second that. All in favor?
Aye.
Opposed, motion carried. That was Frank making the motion, seconded by the chair. Okay,
Thank you, Todd.
you're good to go to the planning
Thank you.
board. Thank you.
Thanks for coming out.
Okay,
Okay, congrats on the new office. Need a lot of paint.
okay.
We did, it has to be repainted after the move.
You have anybody here for the, how do you pronounce it? Milkoff?
Yeah, John. This is Milwaukee as well.
No, this is Mulvey.
No,
No, you just did.
we just did Mulvey.
Okay, Moco.
That's why we got confused.
Yep, we did.
Pull up another chair.
Here, Christie, you should.
That's all.
Howard, there are no wetlands
Is it
on
okay
the property.
rather me take it off of here, or is it okay if I just flip sheets like that, or
Yeah, that's.
doesn't matter?
We're flexible.
Okay.
So gang, this is Emil Zembra. He's the
I'm the architect.
This is Mill
Christie.
She's the owner, along with her husband.
You'll know Alan. So basically, we have, now this is the house after the renovations. Right in here, you probably might have saw, this is the existing house. The existing house right now is, it's like 2,454 square feet. The existing house right now is totally within the 100-foot setback. That's one of the reasons that we're here. So pretty much anything that we do, we have to get a variance for. Existing house. What we're proposing is basically, we're doing an addition to the side, addition of the back over here. There's a new chimney coming here, which we'll show you in a second, and we're putting a new front porch. So the only thing that gets actually closer to the existing property line is the front porch little post. Obviously, everything else is still within the 100-foot setback that we're doing. This is the existing site plan. This is the proposed site plan. So you can see this kind of orangish color is the existing residence. The shaded line with the other orange is the all proposed area. So we're expanding the front porch just slightly. So because of the way the property line is, it gets within about 5 inches closer than the existing porch right now, and it has a roof on it. But not, it's not screened in. I think the original memo from the engineer might have said it was a screened-in porch. It's not. This is a new chimney because the existing chimney goes through the middle of the house right now. So just trying to move it so that it gets more usable space on the inside of the 2 floors. This is an expansion on the kitchen dining area. And this area right here is a screened porch.
What's this other area to the,
I'm sorry.
what's the other area?
In the far left.
This one here, this is a study and mudroom.
Okay, so you're not doing anything for increased bedrooms or anything like that?
No, no. The only thing we're doing is, I think one of the previous memos was that we're expanding the second floor, but it's not getting any closer. What we're really doing on the second floor is they have it's like a knee wall with a slope roof. The knee wall starts at like 3'10", I think, to 7 foot. So we're just raising that up like 3.5 feet, 3 feet to get additional headroom.
In the room?
So our husband doesn't hit his head on the ceilings and stuff. This is basically the same site plan. This is a revised site plan, which I brought copies for the board. This was revised based on the engineer's comments. They had us put a little additional information. We added the 100-foot setback line on here. We addressed, I think last time they were talking about what tree this is, that it's potentially, we're trying to, well, we're gonna do our best to save that tree. It's a dogwood tree. And maybe it can get trimmed. If not, maybe can try to move it if it needs to be moved. But Christy and her husband are seriously looking to try to save that dogwood tree. So that's identified now. And we put additional setback dimensions per their request. From what I understand, we need a variance to the new chimney. We need a variance for the front porch. We need a variance. We're basically taking, there's like an existing second floor, which I can go back to the plan. Well, we'll see it in a second. It has an overhang. We're squaring it off and bringing it down to the first floor.
But you're not touching the foundation?
Slightly, just squaring it off. You'll see that. in
You
one
are
second.
squaring off the
Yes,
foundation?
yes. Because
Okay.
right now it's a bay. I'll show you that when we get to the floor plan. And then we have a dimension here. This is also, we need, I believe, a variance for this addition too. But it's actually at the same point that the existing residence is at right now. We're basically just coming off, but this is still, like the engineer, I think, mentioned that we need to get a variance for that and a variance for the additional square footage because it's within the 100.
And how far is
setback.
the back area?
I'm sorry?
How far is the porch and whatever kitchen expansion right there?
This is the porch right now,
Yeah,
and this is the
how
kitchen.
far is that from the front yard?
I'm gonna guess without taking a scale out, because this is 56 feet roughly to here, maybe 70 something feet to past the existing building.
you really need a variance for that too.
Um,
But it looks like your other corner over in this side might be the,
Yeah,
Closer.
yeah, correct. Everything that's here is closer because it's within 100 foot. So you probably, I don't think that was addressed in the memo.
so 1, 2, 3,
Right.
4. You're talking about 5. Wait,
5
1,
plus the area, I guess, is being increased in the setback. So the expansion of the building. These are the floor plans. So this is the first floor. This is the sitting room. A little, I'm sorry, this is the second floor. First floor is study, mudroom. This is the screen and porch we're adding. And then the shade area is representative of the new eating kitchen that we're adding. And one of the reasons we're renovating this, the ceiling height in here is, it's like 7 foot on the first floor. And then they have beams that are dropped in, so the ceiling is very low in the existing house right now. So we're trying to at least get the kitchen and dining room ceiling up. The rest of it is, we were not changing that. So it's about 7'2" of the existing house. The bedrooms, like I said, we're increasing the wall heights here just to get more headroom. And then the existing bedroom here, we're just adding out to align with the existing wall in the back.
where's the nearest wetlands to this whole project?
To the back here.
So
This is the, what is it, the 100 foot setback line, I think. I'm sorry, 200, this is a 200 feet line.
Okay,
Passes,
so you're
so
well
we're
up.
way beyond.
Wetland
beyond
is
that.
way out. You don't have to worry about it.
And that's the proposed new elevations.
Yeah, I don't see a zone. What zone?
I think it's R10.
R10.
Yeah.
This, yes.
So we're talking 100 foot
Yeah.
front yard
Correct, yes.
setback.
They're R10. It's R10. That was confusing too, because they had two different things listed for that when I spoke to James. I think that's a kind of short version. I can go on and on and on and on, but kind of give you an idea. If you have questions, I can.
No, let's go back over the numbers again. Square foot, you said existing is what?
The existing square footage was 2454, correct.
When you're done with all the
So the new
expansion,
square footage is 3293, 93.
Which is an increase of 35%.
Right, that's correct.
read the notes. Consultant was talking about for the front porch requires a variance of 43.8. Should be that spot right there, right?
Correct,
Yeah.
yes. Mhm.
The west side addition, which would be over to your left there, says you need a 37.45.
Correct. Mhm.
Chimney,
Chimney of requires a variance of 33 feet.
Correct.
Okay. Now, I don't see one, if you're saying you're doing the bay windows.
Yeah, that's 56.58, so that'd be with a variance of 43.42, if my math is correct.
is for the bay windows.
Yes.
And what's the distance?
Can those
now
touch the
to-
ground, Emil? Remember
I'm
that
sorry?
question from Aaron?
It touches the ground, yes.
Okay, so
Yeah,
you
we have a
do-
foundation under.
you do-
There's an existing foundation, we believe, under it right now.
I got it.
And this is where we're squaring it off. You can see that's the bay right now, the light, and then we're squaring that off to line up with the second floor.
Now, the distance from the front yard to that rear addition.
Oh, this here?
Yeah.
We could scale off of that if.
Go ahead, scale off of it.
Got a ruler.
Engineers, go on, go on. Kind of an engineer skill here, right?
No. Not on me.
Do you have a ruler there? Is there a ruler?
Can we go look in the office?
Yeah, I think he's
Be a
grabbing.
nice little project for you.
Okay, thanks, yeah.
Small.
It's Hawk's old house. Remember Dennis Hawkins?
Really?
Yeah, Hawk was the one that worked on it last.
Like 82, so that would be what, 18 feet?
18 feet.
18-foot variance.
Everything,
Nice.
both side yards are way over. so
Correct.
there's
Yep.
nothing there. The rear, of course, is way back too, so there's nothing there, so.
Right.
So, 2, 3, 4, 5 setback variances and one for the bulk.
Mhm.
Okay. Any other questions right now?
I don't have any.
None by me.
I would make a motion to open public hearing then.
Motion by Frank, seconded by Tate, all in favor?
Aye.
Opposed? Motion carried unanimously.
Since Alan told me there's no wetland on the property, I have nothing to say.
So it's on the property, but it's,
I know.
And John confirmed that.
Okay, I'll make a motion to close the public hearing.
I'll second it.
Motion by the chair, seconded by Frank, all in favor?
Aye.
Opposed? Motion carried unanimously. Okay, this should be a type 2 action from a seeker point of view.
So moved.
Motion by the chair, seconded by Frank, all in favor?
Aye.
Opposed? Motion carried unanimously. Okay. Frank, when you do?
Want me to give it a shot? All
Yeah.
right. At the outset, any variances granted are conditioned on site plan approval, because we have to issue a special permit. Probably do these one at a time. I would make a motion to grant a 43.8-foot variance for the front porch.
Motion by Frank, seconded by Tate, all in favor?
Aye.
Motion carried unanimously.
I would make a further motion to grant a west side variance of 37.45 feet.
Second.
Motion by Frank, seconded by Tate, all in favor?
Aye. I would also make a motion to grant a variance for the chimney in the amount of 33 feet
I second it.
From the front, you gotta say front yard.
from the front yard.
Okay.
And I second
Motion
it.
by Frank, seconded by Alex, all in favor?
Aye. Make a motion that we grant a 43.42-foot variance for the bay windows in the front yard.
I'll second that. Motion by Frank, seconded by the chair, all in favor?
Aye.
Motion carried unanimously.
Next, I would make a motion that we grant an 18-foot variance for the new kitchen area expansion from the front yard
In the rear.
in the rear. Yes.
Okay. I'll second that. All in favor?
Aye.
Aye. Motion carried unanimously. Now the bulk.
Make a motion that we grant a variance to increase the size of this nonconformity to 35%.
I'll second that. All in favor?
Aye.
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 Opposed? Motion carried unanimously. Now we,
Lastly, I'd make a motion that we grant a special permit conditioned upon site plan approval being obtained from the planning board.
I'll second that. All in favor? Aye. Opposed? Motion carried unanimously. I'm good to go.
Good luck.
So if we get approval of the plan, we don't have, it's conditioned on
If the
Yeah,
planning board has no
Then it's
issues,
all-
you're
okay.
good to go to the building.
Do you want to, this is a revised site plan for the engineer's
Why don't
comment.
you leave that for the file?
Okay.
Hey, John, can I
How
ask a
many
question on
plans?
5? I know it was granted. Is that because it's two within the 100 feet?
Yeah.
So even though it's in the rear of the building? I got it. Okay.
Yeah.
Very well. Thank you.
I mean, if you're increasing the size of the foundation,
Yeah, I see what you're
no
saying.
matter where you
On the
you
bottom
are.
of it. Okay,
Good
great.
luck with the project.
Thank you.
Thank you very much.
Have a good night.
Thank you.
Thanks for coming in.
Bye,
Everyone.
guys. I'll just take 3. Yeah, thank you so much.
Last but not least.
Thank
Let's
you.
start Yadgar before Alan comes back in.
That ask, do you guys want us present for Yadgar or? anything on that?
No reason why you shouldn't.
Sure.
Yeah, sorry. I just wanted-
Could I have a motion to open the public hearing for the yard guard appeal?
I'll make that motion.
Motion by Frank, seconded by Tate, all in favor?
Aye.
Aye. Motion carried unanimously. Kim, you're up.
Howard, there's no wetlands close to this either. So I'll get that out of the way. Yeah. Right,
Oh, that's it. Was this published? You got that up? Okay.
yeah, I believe it was sent to the office, proof of publication to the General's office. Yeah, yeah, I'm pretty sure it came in last week and then we sent it.
Okay, good.
You bet. Last week I sent to the board, and there's a lot to read here. So what I tried to do is summarize what the issues for the appeal were. There were a couple of determinations or letters from Mr. Finley dated December 15, 2023 and December 21, 2023. When we filed the initial appeal in January, I attached them, and the argument in there is a little bit lengthier, but it has a lot of backup information, including a determination from James that he issued in May of 2023. And that determination, no appeal was taken from that determination. And James in part determined in May that the lot would not be eligible for a building permit for a pool. And then it took some time. The Yadgards resubmitted an application. That's part of the issues, the application they submitted that then prompted, we were here, Ms. Ward from Josh's firm was here one night. And then again, Mr. Finley issued a couple of determinations, which at times I have to confess, I don't completely understand them. So to begin with, it doesn't jump out as a use variance. I don't doubt that, but we spent, I think, the whole evening talking about essentially parcels that are a lot like this, but not quite, in that this parcel is considerably smaller. And when you use the determination, James's in May of 2023, he determined a couple of things relevant to this issue. The first was that there was 9,050 square feet already on the lot, and that the lot was permitted to have roughly 7,500. I don't remember the exact number. And therefore it was already over the bulk regulations and therefore could not be expanded. James also concluded that there was a temporary, let me change that. There was another driveway on the property, but he was not able to measure it. And we took from that in fact, he observed it, but he could not determine how large it might be. So there was, in all likelihood, greater than 9,050 square feet of improved land. It was probably closer to 11,000, maybe a mid 11,000. So in any event, when
part of the application looks like an area variance, but it's really, in my view, a disguised use variance because 391.7, which again, we've been talking about in every application so far this evening, those were extensions or enlargements or modifications of existing structures. That's not what this application is. And that's also what James Finley did consistently determine that. And because the coverage is already exceeded by quite a bit, and if you use the math and you count the other driveway, it might be close to 100, well, probably 80% over. That when you look at 391.7, it doesn't allow for new structures. It allows for enlargements, expansions, extensions. And what James concluded was that because it doesn't talk about new structures, it means they're allowable. And we would submit it means the exact opposite. Because it doesn't speak of new structures, it doesn't allow for new structures because they're completely separate. Now, to reach a logical extension or an illogical extension of what James said is, if you conclude that 391.7 does not apply to new structures, it would mean that someone doesn't have to get a special permit or get site plan approval if they were going to add 1,000 square feet. Because in his view, it's not included. 391.7, of course, is what triggers site plan and special permit review. If you added 2 feet to an existing structure, you'd have to get those things. And so when you read the statute or the local law that way, it really doesn't make any sense. So I could put a new structure in of indeterminate size, not need anything other than a variance, a coverage variance. I wouldn't need site plan approval. I wouldn't need special permit. But if I make a tiny modification to a non-conforming structure, I have to do those things. And the reason I'm pointing that out is because it doesn't allow for new structures at all. Read the language carefully. It allows for extensions or modifications. The 4 applications we've dealt with thus far this evening. And so back to the original point is, sure, there are pools around. I know there are pools around. But there are not pools around on non-conforming structures that have already exceeded the coverage requirements by so much. That's why it's a use variance. Because the law of variances says that if it's permitted by the zoning regulations, but it needs dimensional help, it's an area variance. This structure as proposed is not permitted by our zoning regulation. When you apply the different provisions, first of all, is it over the coverage? Yes, it is. Indisputably. Whether you measure the second driveway or not, it's indisputably over. Secondly, is there any provision of our law that allows a new structure to be added to a non-conforming parcel like this? Unless it's in 391.7, it doesn't exist. Again, James Finley decided that, and I'm not critiquing James for his diligence because he was diligent. He decided that because it's not described, it's allowed by omission. And that's not our opinion. And the case that I cited, I'm not going to get into the law, but the case that I cited, in my view, is squarely on point because, again, if you follow the theory that there's pools around and therefore we ought to be able to have a pool because it's allowed by right, that's the theory. If you look at the DeVore case, you could build by right a commercial building. It was allowed by right. You could not build a 4-story commercial building. That was not permitted by right. They applied for an area variance and were granted. And the court determined this was an area, this was phrased as an area variance. It's not an area variance. It's a use variance. They're trying to do something there that the zoning regulation does not permit. And that's exactly what's happening here. Second issue is this road. The argument's been made that it's temporary. It's not temporary. It's been there for quite a long time. And that's why the gentleman from Four Seasons, they put item 4 down to stabilize it so they could bring equipment in. The road had to be there in order to have item 4 put on it in order to stabilize it. So it was there. There's photos that I included with the appeal. There's additional photos that they're not great, but we got them from the internet. And you can see the tracks where the road is. This is in 2009. This is in 2014.
Wait, is this the road you're talking about there?
So this is the driveway, Frank.
Yeah.
This, see these tracks?
Oh, okay.
This comes through the woods. It spurs off over. I can see it from the, the
Does
right of way.
does it come into the back of Yadgar's
Comes in
lot?
here. Yeah, that's how they brought the equipment in. So the road is already there. They stabilized it with some, looks like crusher stone that they put down, and there's a picture in the appeal that we submitted of the, looks like a tracked excavator that's coming in off that. This wasn't built for construction of the pool. It was already there. It was probably made better because they needed to, bring in some pretty heavy stuff. But that's how they came in. They couldn't use this road. It doesn't, the topography doesn't permit it.
What's the year of that photo? 2009? Do you think?
This is 2014.
14.
This is 2009. It's a little fainter there. One of the reasons. This is 2021. Square footage is 7579, by the way. The one I couldn't remember what is permitted. If you look at James's letter, I believe it's May 3rd. Yeah, May 3rd, 2023. James said, I wasn't able to measure it. So he doesn't discount it as not counting. He simply says, I wasn't able to measure it. In one of his determinations in, I think it's the latter of the two, definitely in December of 2023, he basically said it's temporary. Our code doesn't distinguish between temporary or permanent when it comes to building area. It's either counted or it's not counted. In James's initial determination, he was suggesting, I believe, that it counted, but it was already over, so he didn't proceed to count it. In his most recent determination, he essentially said it's temporary, so I'm not going to count it. Why that's relevant is because when you have to look into, if you determine that this is only an area variance, in order to determine what you're granting a variance from, we have to know what's on the site. And we would suggest that that road needs to be counted for the determination. It was not built for this construction. The next point I make in the summary that I submitted to the board was that, and I brought photos of this as well, is one of the things, and I raised this when we were here for the area variance, Mr. Mackey's firm had filed, is the determination of the square foot and how big the house is. And James seemed to be pretty focused on what it was in 1987. The code clearly says May 13th of 1971. These were taken from the internet. They're also included with the appeal. This is the house on the parcel in, this is the house in 1970. This is the house in 1980. 2009. This is the house in 2009. Sometime after 1980, the house was, according to what we can see, significantly enlarged. And we don't know if it was in 1987, but it was sometime after 1980. And the threshold determination is what was it in 1971? Again, to determine how much coverage can be dealt with here. This is not the Milkoff lot that's 7.5 acres. This this lot is well under 2. So the amount of land that's covered with stuff is pretty extensive. We submitted a lot of information to James to suggest that, look, the measurement needs to be from 71. James determined that 87 was the date, and that's the measurements he gave. I'll leave these with the board as well. These black and whites.
I'm sorry, it's 70.
There's a date on each one.
Date on each one.
Yes.
Okay.
Right?
What are these from? Besides the internet?
Hey, Alan, what I'm gonna ask you to do, do you mind? I'm sorry for the interruption.
No, sure.
Can we, maybe it's just so your record is clear,
Mhm.
perhaps we can have whatever you're using, like
Sure.
marked, if thanks. You know where I was going.
Yeah, I got you.
Thank you.
So let's do this. Pull these back.
Exhibit 1, 2,
Yeah. So I'll put numbers on them. right, and I'll circle, and you start with the red plate. Exhibits 1, 2, putting in the upper left-hand corner, 3, they are appear to be color, and they really relate to the road. They also show the size of the structure. 4 and 5, black and white. And,
They were
I'm sorry,
obtain maybe
size of the road.
from the historical part of parcel access where you can
I
go
did-
back on that.
Jim Cornell, who's on, he and Lee were able to go on the internet, look these up and give them to me.
Got it.
I did not do that.
Okay.
But I have no reason to doubt their authenticity.
I don't.
So that's issue 3. I raised this issue number 4 on appeal because I'm not sure what James determined. But as I said earlier, he seemed to suggest that because it was a new structure, it didn't need site plan approval or a special use permit as opposed to an addition. He didn't say anything. So I'm bringing it up now because I think that if this passes certain hurdles, and if you conclude it's an area variance, and while I disagree with that, clearly, if you're going to add a 600 square foot pool, you need site plan approval and a special use permit, as opposed to adding a 2-foot addition. James, I don't know if he answered that. I couldn't determine that he did. So we took it up on appeal. The last point is, in James's May 3rd, 2023 determination, he did conclude there was a violation on the property. And I don't know why he decided that you don't have to cure the violation, but he in part suggested that the measurements from 1987 somehow relieve it of being a violation. And I didn't quite follow James's logic there, but in an unappealed determination, he said there's a violation on the site. The violation has not been cured. I think it's incumbent upon the board to determine first, are there violations? If there are, the applicant should come in compliance with our code as it's written first. In order to do that, there should be a proper application. It should be for a use variance. It should have proper measurements because it will also need relief on size. And that way, a complete record exists not purely for the board, but also for interested parties. And I don't know how to handle something when you get a letter that says there's a violation on the site, and that kind of is the end of it. The local law that we have does seem to suggest in parts that he has to actually issue an order for there to be a violation. But I think there's language in the code that would allow the ZBA to say, look, until the violations are cured, don't ask us for anything new. Do you have any questions?
I don't have anything other than what I already told you about.
You're saying James is the only one that's made this statement about violations on the property. And you have no idea what that is.
No, I know what it is, John. I can show you it. In the appeal, in my unrelated letter dated January 11, 2024, included within it is James's termination of May 3rd, 2023. On page 2, third to last paragraph, it says, therefore, the property would be in violation of Appendix B of the zoning code, and no building permit could be issued for the proposed swimming pool. That was not appealed. You want to see it now?
That's still tell me in my mind what the violation is.
I think it was because the lot had more than 7,500 square feet of coverage. I think that's what he was talking about.
No, I think what he was, if I meant, I think what he was referring to was that there was back then it was the lot coverage issue, the 10%, and that he couldn't issue a building permit until a variance was issued on the 10%. So I recall, I think he addressed it also in a subsequent letter, in more detail, but that's what I believe he was referring to.
I think that's correct. The paragraph before that I read says this, same letter, this parcel being 1.74 acres, comma, or 75,794 square feet. The existing coverage would already exceed the 10% limit of 7,579 square feet. Therefore, the property would be in violation of Appendix B.
I think I got it.
Can I ask Alan a question?
Sure.
Alan,
Sorry.
that's okay. No, don't play. So the use variance, if it requires a use variance, your argument is because of its non-conforming qualities? Is that the reason why, is that what makes it somewhat unique, that's why the use variance is required? Because it's a prior non-conforming lot?
Following DeVore, yes, that's
Okay.
part of the reason.
All right, if that's part, what's the other one?
The primary one, Kyle, is that there's no question the coverage is exceeded. That doesn't seem, no matter what letter you read from James,
Okay.
the coverage is, there's too much improved area already. Coupled with the nonconformity on the lot, meaning the lot is subzoning at 1.74 acres. When you read 391.7 and it talks about what you can do up to 25%, it talks about expansions. It doesn't talk about additions, new structures. This is an entirely new structure. And that's why it's a use variance, because are there pools in RR10? Yep. And are there pools in RR5? There are. Are there pools in other non-conforming lots? There are. Are there pools in other non-conforming lots where the coverage has already been exceeded? Not that I'm aware of.
But the case you cited, I thought the case you cited, the issue was not a new structure, but it was actually an enlargement of an existing structure.
It was a new structure.
Didn't they need a wasn't the issue was that they needed a variance to go over a certain height? And that of the actual structure itself?
It was a new structure, and you were allowed by right to build 2 floors.
And they wanted to go
They
4.
wanted to build 4.
And it was that additional, it was that additional 2 floors on the structure that required the use variance.
Well, I think what they were saying is you couldn't do 4 floors in that zoning area. You could do a commercial building, but you couldn't do 1 of 4 floors. And if you look at it from the perspective of an area variance, it just looks like a dimensional change. You're adding a couple floors. What the appellate division was saying, no, you're allowing something that's not even allowed by zoning. You're allowed 2 floors. I can send you a copy of the opinion. Did you read it?
Yeah, that's why I knew how many floors it was. I didn't pull that one out.
No, I just thought there were questions you had.
Yeah, no, that's cool.
I think it was an entirely new building. I'm quite positive.
All right, it might be.
It was an old non-conforming lot. Let me see if I can find it.
I'll look at it again. I was just curious what, I thought the issue that the appellate division had was that they were exceeding the number of floors that was otherwise permitted by zoning. And also as a result of that, it was bootlegging they would be bootlegged into some other approvals, such as an expanded parking. And that was in part what I think the court was offended by, but
That's what I had it here.
I don't want to take up everybody's time to read the decision.
No, I'm not doing that. I just wanted to tell you whether I think it was new or not.
Yeah, okay.
It was new.
Okay, and Josh has answered it. Yeah.
All right. So, then the other question I had was is the 1971 law apply to there's 2 separate, let me back up, sorry, so I'm not trying to, I don't want to confuse it. There's 2 separate issues, right? there's the 25% expansion. And then there's the lot coverage rule. Two separate things, aren't they?
I think the code says it's one or the other, the lesser of
Right.
coverage or 25%.
Right, it's to expand the structure, right? It's either 25% or it's a maximum of 10% of the lot coverage.
I think it's the lesser of
But
those.
you're right. The
Because with
lesser-
Milkoff is a good example. That is a big lot.
No, I agree with you. So what my question is this, does the 1971 rule or law apply to both the 25% and or the lesser of the 10% lot coverage? And your answer, I
Can I
presume,
see the
yes.
code? I think it's yes, but it's a
Yeah, of
question.
course. Yeah, I'm not trying to trick you. I just want to, it's, to be fair to you, it's not the, I wouldn't call it a, no, I'm not gonna call it.
It's 20, I think it relates to the lesser of the two of the 25%. So it can be enlarged by up to 25% of what it was in 71
Mhm.
or the max coverage that's not tied to 71, whichever is less.
Yep.
Does that answer?
It does.
Okay. And that's why I think the 71 measurement matters.
Okay.
Because it's a less, not greater.
Thank you.
You got?
Okay. Well, this is a public hearing. Like, Alan, are you?
No, I'm all set.
Okay.
Question?
Is there anybody like to speak for or against this application?
You want me to come up?
Yep.
All right.
No, I want to.
Joshua Mackey Butson Whalen for.
We get you on the
Josh?
recording, Josh.
Stay.
Yep.
All right. I have a written submission here, and I can sense that attention spans are waning, so I'll do my best to paraphrase it, but I've got copies for everybody. Thank you.
Thank you.
All right.
Got one for Kyle.
I was just thinking that, yeah. Hold on. That's you. You got one, Alan?
I do, just.
All right. I know there's a lot to unpack here, so I'll do my best. As I said, I'll try to paraphrase to the extent that I can. Obviously, we oppose this appeal by the neighbors, Lee and Jim Cornell. The submission that you have in front of you addresses each of the 5 points in the Cornell appeal, in particular the summary. From the outset, it's not entirely clear to me the full extent of this appeal. You know, there's some discussion about the May determination. There's discussion about Mr. Finley's opinions as to the road. I don't see some of the things that are mentioned in the December determinations, the December 15th and the December 21st determinations by Mr. Finley that have been talked about tonight. So I'm sure your attorney will do his best to help clarify exactly the full scope of this appeal, but it is limited to those two determinations. I just asked if I could have copies and make a request on the record of the exhibits that were introduced tonight. Alan, if you want to send them to me later, or
Yeah. sure.
or can I take
have-
those?
No, those are the only ones I have. That was but what I'll do is I'll come up and, well, they're color. That's why. Yeah, so I'll come up and I'll figure out a way to get copies.
That's fine.
Yeah, that's fine.
All right, so the summary of appeal recites 5 issues. I'm going to address each of these. Number 1, Cornell is wrong that the application requires a use variance and not an area variance. There's an assertion that this application for rear and side yard setbacks requires a use variance as opposed to an area variance. What's being asked of you is that you render a legal decision without a vote on the pending application that a use variance and not an area variance is required.
The effect of this is to have you reform the application. The foundation of this argument rests upon the claimed existing lot coverage that Mr. Finley calculated as 9,050. That's the number. At one point in time, back in March of 2023, he determined it was 4,577 existing. That was before the debate started about the driveway interior road. Cornell cites section 391.7 and appendix B of the bulk regulations that limit lot coverage in the RR10 district. That's where this is, to a maximum of 10% of the total lot size. So the Yadgard property is 1.74. This acreage equals 75,794 square feet. Therefore, under the code, the maximum is 7,579 square feet. The driveway at the Yadgard property is included by Cornell and at times by Mr. Finley in the calculation, because lot coverage would be 9,050, as I said, and thus render the lot non-conforming. There's been casual references to some old road once located at the Yadgard property without any support. I do see on the table the pixelated images taken from years back that purport to show some secondary road. There's no record of such road or any public thoroughfare existing now or in the past on the Yadgard property. Perhaps sensing the weakness of this argument, Cornell tries to assert that there is a temporary construction road at the property that maybe Four Seasons put down some material and is using that to bring back equipment to construct the pool. My answer to that is, so what? Yadgard, going way back, remember this all started back in August, September of 2022. Construction commenced after they were issued a building permit by the town. They had to get equipment up there. Any approval, at any time by this board, by another board, I'm sure we'll have a condition that a secondary road, construction road, whatever you want to call it, to the extent that it exists, must be removed and the ground restored. And I'm sure the Yadgards would agree to that. The Google Earth images that are being used simply aren't reliable. Courts have routinely held that these are not sources which should be relied upon. I hope that the ZBA will find them equally unavailing. Cornell wants the ZBA to believe that there is a road at the Yadgard property so that what is actually a driveway falls within the definition of building area in section 610 of the code. So building area is defined there as all land covered by structures, interior roads, parking areas, sidewalks, and loading areas. The word driveway is conspicuously absent from that definition. The code does not define driveways. However, the word driveway is found 38 times in the code. The code does not define interior roads, which is in the definition of building area. Interior road is found 4 times in the code. If the authors of the code intended driveways to be synonymous with interior roads, they would have stated that. So since there's no definition of interior roads or driveways, you look to other sources like Webster's, and there we can see driveways defined as a private road giving access from a public way to a building on abutting grounds. It defines road as an open way for vehicles, persons, and animals. Cambridge Dictionary defines driveway as a private area in front of a house or other building onto which you can drive and park your car. It defines a road as a long, hard surface built for vehicles to travel along. Clearly, the Yadgard driveway is just that. It's a driveway. It's not a road. It's not a public thoroughfare. It's not an open way, and it's anything but long. The proposed pool is 720 square feet. adding this amount to existing structures at the Adgard property. Actually, that number's actually been reduced. There was a subsequent application, if you recall, where they reduced the size of the pools. It's 600 something.
100%.
Yeah. Adding this amount to existing structures at the Adgard property, total lot coverage, excluding the driveway, is 5,297 square feet, or 7%. That's below the maximum lot coverage of 10%. So for these reasons, the ZBA doesn't need to evaluate whether use variance or area variance is required. No variance for lot coverage is necessary. There's no precedent by this board where a lot coverage excess resulted in the need for a use variance. It hasn't happened. In fact, in one recent application that I know members of this board and others sitting in this room know a lot about, a citizen named Marsha Renner applied for area variances to allow for the installation of a pool on a lot size 0.46 acres. That's 20,037.6 square feet. There was no mention there of lot coverage at all, despite an apparent overage. So here it is. And Renner, that's the RM2 zone, 10% maximum also applies. The maximum lot coverage there is therefore 2,003.76. The rendered house footprint, you don't take the total square footage, you just take the footprint, 1,008. That 16 by 33 pool, not including the coping or the decking, is 528 square feet. It appears that the rendered driveway is roughly the same size as the pool. Let's call it 528 square feet. This totals 2,064 square feet. And that, again, doesn't include the decking around the pool or its coping. Yet, there's no mention of needing a use variance in the renter proceedings, even though the addition of the pool appears to have exceeded the allowable lot coverage. And remember, the use of the property there was basically a commercial use, an Airbnb. The ZBA should consider its pattern and practice when determining this appeal. Assuming that the driveway is included, there's still no reason for a use variance. If any variance is required for lot coverage, it's an area variance. I'm sure you're all familiar with Town Law Section 267, which defines use variance very clearly as the authorization by the Zoning Board of Appeals for the use of land for a purpose which is otherwise not allowed or is prohibited by applicable zoning regulations. It defines area variance as the authorization by Zoning Board of Appeals for the use of land in a manner which is not allowed by the dimensional or physical requirements of zoning regulations. That's what's happening here. The pool is allowable under the code in the RR10 district. It is not a prohibited use. In order to comply with the dimensional requirements of the code, the Adgard needs area variances, not a use variance. The argument that a use variance is not an area variance and not an area variance is required must also fail under long-standing New York case law. This DeVore case, we've talked about this a lot. There's been a lot of correspondence going back and forth, and it simply has no application here. It's a 1979 case where the court reviewed not just the issue of height, a number of stories, which was mentioned earlier, but there were 7 area variances that had been granted by the Zoning Board of Appeals in that case. There was a height variance, that's right, 4 stories as opposed to the allowable 2. Off-street parking variance, 193 were proposed instead of the required 205. There was a variance for a loading berth, 1 of them, instead of the required 4. A variance for parking and loading facilities to be in landscape. There were a lot of variances here. It is a small lot. I looked that up on Google Earth, and it's a little triangle wedged in between 2 sections of the Northern State Parkway. The court considered all 7 of those variances in rendering its decision. The sheer volume of those variances should be telling. The court described the history of the property having been once, in fact, recently, just a few years before, residential, was rezoned to commercial. The holding in that case wasn't that the Zoning Board of Appeals determination is annulled because a use variance required. It was because the applicant didn't demonstrate financial hardship
And you've heard about that before. You have to show in dollars and cents that you can't make a reasonable return on this property if you stick within zoning. That's why the court overturned that decision, not because it was in dictum, we call it. I want to impress you with some Latin words now, that they went on to say, and by the way, everybody, that decision should be annulled, but we also note this is really a use variance in disguise. Fine, but that's not the holding. They went on to say that an unauthorized 25% increase of permissible building space from 30,800 to 38,480 square feet effectively expanded the permissible use of the building. More people coming and going, more cars. The property was granted an additional benefit of the relaxation of the parking requirements. The court viewed this outcome as an expansion of use by allowing more traffic and visitors to the property. There's nothing in the Yadgard application that comes anywhere close to the level of variances in DeVore. Again, the DeVore court dealt with commercial uses, not a residential use. Think about it. If that interpretation as proposed by the appeal is accepted, there's going to be a slippery slope. Residential properties seeking area variances for addition will be held to a higher standard of use variances. That's not what the court in DeVore intended. It is plain that DeVore has no impact on zoning law by numerous Court of Appeals decisions, the highest court in the state. I go on in my submission to cite a few of these cases where, like in Kahn versus Zoning Board of Appeals, it's a 1996 case, an area variance involves no change to the essential character of the district compared to an area variance, which deals with setback lines, frontage, lot size. This is what we've been talking about. In Viteri versus Zoning Board of Appeals, this is a 2022 case. This is important. The court held that New York courts do not defer to administrative determinations by zoning boards as to what constitutes a use variance and what constitutes an area variance. In case after case, courts have independently determined as a matter of law whether the matter at issue concerned a use variance or an area variance. And two, apply the deferential rational, when they say we're going to defer to the board, we're not going to step in the board's shoes. They only do that upon review of the zoning board's determination, finding the applicant satisfies the test, obtaining the variance in question. The court of Viteri cited numerous cases in support of its holding. In other words, it's not within your purview, or another way to say it, you don't have jurisdiction to decide whether this is a use variance or an area variance. And I'll add to that, this is an appeal of Finley determinations, and Finley doesn't make any determination about that. So why are we talking about it? Point two, the road driveway. Cornell fails to prove the existence of a road on the Yadgard property. There's no evidence of a road on the property. What is actually there, what is actually the driveway may be included in the lot coverage calculation, although as stated above, there's an equally plausible interpretation of the code, which finds that only interior roads and not driveways are counted in determining lot coverage. Maybe this explains why in Renner, there was no mention of lot coverage in granting those area variances. The ZBA likely did not count the Renner driveway and thus concluded there was no overage in lot coverage. Point three, there's some mention by Cornell that sometime between 1980 and 2000, the house was doubled in size. They use the word double. Again, Google Earth granulated, pixelated pictures showing somewhere in that period, there might have been an addition on the northern side. Well, I think it's the northern side of the property, if I'm oriented properly. But no proof of size, no proof. Is it?
I think so. North is that way, right?
I thought Wes was looking out the front door.
And towards the Shunbeck is what direction? North.
North.
North, so it would be the south side.
All right.
Yeah, this is where it would go that way.
I see. Okay. There's simply inadequate evidence to support this claim other than the pixelated imagery showing that sometime since 1980, or perhaps earlier, a small addition to the house occurred. Cornell argues that section 391.7 of the code permits expansion of the existing building by 20% of what was on the lot as of May 13th, 1971. But there's no competent evidence of that expansion, assuming it happened at all, or that it was greater than 25%. For this reason alone, this argument that 391.7 should apply must fail. Assuming for a moment that the Adgard lot is non-conforming, Mr. Finley reasoned in his December 21st, 2024 determination that 391.7 does not apply because a pool is not an expansion or enlargement of a non-conforming structure, but is instead an entirely new structure.
That should be 2003 or 2002.
Yeah,
23.
we're not there yet. The code defines pool as an accessory structure. This kind of rolls into some of the other arguments by Cornell. The next 1.4, Cornell argues that the pool requires a special use permit and site plan approval. All I'll say to this is that, again, RR10 allows pools by right. No special permit is required, but they might need area variances as they do in this case. To the extent the ZBA has discretion or is required to refer the application to the planning board for site plan approval, the Adgard's going to comply. They want this pool. I don't think there's anything more to say on that point. Last one, number 5, on this issue of violations. You know, we're all sitting in this room kind of guessing what Finley meant, I think. Not how I would conduct a hearing. I don't know if Mr. Finley is available to give testimony, but there's a claim that the Adgard property has a, quote, actual violation against it due to the lot coverage of 9,050, whereas 7,579 square feet is allowed. For the reasons I've already mentioned, which demonstrate there's no interior road on the Adgard property, this claimed violation is without merit. Even with this finding, Mr. Finley's May 3rd, 2023 determination is a qualified one at best. What he actually says is the property would be in violation of Appendix B, not that it is in standing violation. No formal violation has been prepared or served. There's been no hearing on this issue. There's no final decision on this issue, which might require Adgard to appeal. To call this theoretical, debated, and equivocal calculation of lot coverage an actual violation would violate Adgard's right to due process and contradict all pattern and practice by the town. For the foregoing reasons, the appeal must be dismissed in its entirety. Do you have any questions?
Thank you. Thank you.
Thank you all.
No questions, Josh.
No questions. Yes.
This is Jim Cornell.
It won't be long.
Something new?
No.
Alan?
Just to follow up on some of the points Josh made is
Hello.
town law and the zoning code allows for 2 types of variances, use and area. So it does make a difference in terms of how you apply. You have to apply for the right one, for the zoning board to be able to entertain the right one, which is why the court in divorce said you applied for the wrong one. And the board, of course, it has jurisdiction to decide what kind of variance should be before it. Why would town law exist if it didn't distinguish between one or the other? How would someone know how to apply? So our contentions, obviously, you've got to prepare the right one. The right one has not been submitted. It's pretty telling. We've been here for a long time, since the initial, at least a year. And in that year, including plenty of notice from knowing we were appealing, the Adgards did not come in with proof of what was there in 1971 or 1987. The record is barren, but it's only barren on the Adgard side. The record that the Cornells have submitted is undisputed, and including these photos, including the photos that were submitted in January. Look, to put it plainly, if they've got something different, you would think they'd come forward with it that shows something different. They don't, because what we submitted is true. By the same token, the May 3rd determination of Mr. Fenley was never appealed. If you have a problem with something, or you feel there's a violation or that should be challenged, or a measurement that's wrong, you appeal it. You do what we're doing here. You don't sit on your rights and let, and let someone else figure it out. This determination in May 3rd, 2023 is controlling. There's no measurement that the board could even frankly consider other than what James determined to be at least 75, 79 square feet. And if, I'm not going to read from it because everyone's been patient, but if you read on page 2 of his letter, he talks about this interior driveway. He knew it was there, and it's our contention it should have been measured. There's no dispute it's there. There's a dispute about what's been, how it's been changed, but again, I don't think this evening, I don't think Josh is disputing and improved it to bring in equipment. So it's important if in the applicant's case, if he thinks we're wrong, or if we said something that's incorrect or factually unsupported, come in and prove that. Don't just say it's unsupported when you're looking at things like this, which are unequivocal.
Can you say where these came from? Because I asked you earlier. You didn't answer.
This is Jim Cornell.
Printed them, and Mr. Cornell. And
Yes, I just wanted to,
Okay.
They went on
just want to say,
to
it's all from partial access.
and printed them from them. And I think they can hear us, but
Yeah, I can,
I saw the same thing this afternoon. You can go on Dutchess County Parcel Access and there's a little tab on the bottom that says historical aerial. But, you know, I'm sorry, Alan, I don't want to interrupt
good, no, I
you.
appreciate
But-
you pointing that out.
But
those are all from partial access.
yeah, there's really no
This is the Cornell's house.
understood. This is their current house right here, right?
Correct.
By the way, the Cornells used to live over on this side where there's a tennis court, a basketball court, a pool. Just saying.
All within the square footage allowances as measured by Mr. Finley when they sold the house to ensure that they were in compliance with the law.
They moved there this summer. I don't know what evidence that they can dig up from the past. Mr. Finley was very, very careful in one of the determinations, the date right now, I can't think of it off the top of my head, but he went through the file on this property and showed when building permit applications were applied for a front porch, I recall. There were 2 letters of no violations not long ago. That's the record. I mean, we're not going to come up with some extraneous information to try to, you know, rebut something that we aren't obligated to do. This is not reliable. This doesn't prove that there was an expansion greater than 25%. It doesn't speak to the lot coverage. I mean, the board is free to consider it and give it whatever weight it wants, but I'm here to tell you this is unreliable and you can't make your decision based on this alone.
Okay.
John, I didn't even get to finish the reply, and Josh picked it up. I would submit to you that unless someone doesn't believe what's on the publicly available site, there's nothing more reliable than what anybody can download. And just calling it unreliable doesn't make it so. The last point, 2 points I wanted to make was the issue of renter was brought up. I don't remember a neighbor ever claiming there was a coverage issue, because I was involved in that case as well. And I remember the neighbor suing over the wetlands law, but I don't remember the interested party ever saying there's a coverage issue. Because if there was, I'm sure the ZBA would have handled it. It was brought up here. That's where it's very different. The board didn't conduct a secret meeting and say, geez, we're going to hide the coverage problem here. Never came up. Never came up in the litigation that was filed by Josh's firm. To try to say, well, you did it there, so you can do it here, that's just, it's so out of this realm as reasonable because it was never brought up. I'm not sure the math is right in any event. The last point I'll make is if you have the inkling or desire to read DeVore, don't let me tell you what it says. Don't let Josh tell you what it says. I know Kyle will read it. Just read it in terms of.
I agree with, I have to respond to one thing because
That's okay.
I'll
leave it up to John if you respond.
I don't think that the fact that it wasn't raised in an objection in the rendered application means that the board didn't have an obligation to examine lot coverage in that case. That's all I'll say to that.
There's an appellate issue called preservation. It's a basic Hornbook lawyer rule that if we don't bring it up, we waived it. And that applies here. So if I never bring up this coverage issue and you, bingo, you give Josh's client everything you want, and then I say afterwards, oh, geez, I forgot. I'm out of luck.
Nobody's trying to reopen Renner here. I'm pointing to precedent. That's all I have to say.
Thank you.
Thank you.
Thank you.
Thank you.
Anybody else? If not, I would make a motion to close the public hearing.
Second that.
Motion by Frank, seconded by Tate, close the public hearing. All in favor?
Aye.
Opposed, motion carried unanimously.
Thank you, gentlemen.
I think it's yours.
Now, Kyle, we have what, 60 days to consider and put together our findings on this?
Yes, 60 days.
Okay. We're,
If
want to
you-
do that, or they want to make a
Lee and
decision
Jim?
tonight?
I'm sorry, you already closed the public hearing.
I
I'm
would-
gonna
I would-
ask you if they
I
want.
would recommend to stay the decision until we put something.
I agree with that, because there may be some issues that we want to go into executive session with our attorney for.
Kristen, ultimate time, come on here, copies of
Do we need that as a motion, Kyle?
No, we don't.
Okay.
The only thing I want to say real quick, well, I'll wait till Alan.
Sorry, Kyle.
No.
Can you just scan these to me? Then there'll be color in the scanner, and then I'll send them to Josh.
Okay.
Yeah, that'll
I think
work
the town
fine.
has a color scanner.
Well, if she
Yeah.
emails them, it's fine.
Okay.
Yeah.
Sorry.
No sweat, Alan. Do you want that transcript as part of the record?
Yes.
Then I'll need the printed transcript. Okay.
What's your turnaround time?
Um,
Oh, we're gonna throw you on the spot. now.
Yeah.
yeah, I think they said 7 to 10 business days.
Okay.
All right, great. All right, so as long as there's no issues with that, and then anything else, let me, if I may just add one other question, John. Is there anything else besides the transcript that, Alan, you want to make sure is included in the record?
Well, the initial appeal, Kyle, you
Other
have.
than what you submitted? Yes.
um, Would James's file not be all subject?
It may not be, so,
I'll take a shot and look at it, see if there's
Thank you.
anything else I want to include.
all right, I appreciate that. And also, same for,
Now, if there's something additional submitted, I'd like an opportunity to.
all right, so then what I'm gonna suggest this, if I may, Mr. Chair, is with the consent of the appellant, that the time frame by which we issue decision will begin to run once we get the copy of the transcript and confirmation that Mr. Rappier has given us whatever he wants to have included, make sure it's included in the record. Doesn't mean we're gonna consider it, because it may not all be relevant, but I don't want there to be any misunderstandings as to what's in the record. Right, Josh?
Exactly.
Yeah, I don't plan to submit anything new. I plan to give you the transcript.
Yep.
And anything that's already been sent to James.
Right.
I'm not gonna write more letters, I'm not gonna reply.
No, that's what I mean. I
Yeah.
don't, no more submissions
Yeah,
like
yeah.
in terms of arguments. Same thing for you, Josh, right? No more submissions. Just that if there's anything from from the Finley file, is really probably the only thing that would be left.
Would either be letters from us or Josh's firm to Finley, or
Right.
what's in the Finley file, that's
Correct.
true, and the transcript. And I'm certainly comfortable with essentially staying that time period until you have all that stuff. I think you need the proper permission consent.
Yes,
Yes.
yeah, I have your consent too, correct?
But how long are we gonna stay it?
Well, I mean, I think it's a reason, I don't think this is gonna take.
I know you gotta wait for the transcript, but then so.
By the time we have that transcript, you guys will have already.
Okay, so the
Outside date is.
outside date is the transcript.
Is the transcript.
That's agreed.
Fine.
All right.
Okay.
All right, thank you all. Thanks for your patience, folks.
Okay, we have one additional item. We want to read.
Yeah, we want to talk to you about,
Thanks for helping
Time started the meeting. Kyle,
we'd like to move the time to 6 P.M.
I vote aye.
That helps, yeah,
Yes.
perfect.
I vote aye.
Thanks.
Most towns are doing it early now, and
Yeah.
Poughkeepsie's 5. Highland is.
Later is better for me.
We figured if it was 6, it still gives people who work till 5 o'clock an opportunity
Plenty
to
of
be
time,
here.
I agree. I think 6 is great. Oh.
Now, do we have to do anything formal to do that? Or
You just take care, Alan. Just take care. I
Good
would just,
night.
just make a motion, second it, vote on it, and you're good to go.
All right, then I would make a motion that commencing with our March meeting, the meetings commence at 6 P.M. now, going forward.
I second the motion.
Motion by
I do,
Kyle,
Alex.
seconded by Alex. All in favor?
Aye.
Opposed, nay. Motion carried unanimously. Motion to close the meeting by the chair. Do I hear a second?
Second.
Seconded by Tate. All in favor?
Aye.
Carried unanimously. Somehow we've got to get the fact that the meeting now is at 6, posted
Yeah.
on
On the website,
So starting in March.
March.
yeah, and all public hearing notices will have the time change too.
Oh, so
we gotta do that for Alexander.
Okay.
Change that.
Oh, good thing we didn't send it out.
Yeah.
You get all that?
I don't suggest.
I'm sure you did.
Okay.